Welcome again to the Peak Wealth Podcast. My name is John Perry. I'm your host from Steel Peak Wealth Management. Today I am happy to welcome back Mark Gotlieb, trust and estate attorney extraordinaire. And this is going to be hopefully an ongoing series of episodes we record together about various aspects of estate planning. Last time we tackled the very large topic of wills. Today we're going to talk about trusts, a little bit in a broad sense, and then some specifics about trusts. But before we start, just for those people who might not have heard our first episode together, give us a little intro about yourself, Mark, and your practice.
Thank you for having me again. This is one of my favorite things to do, is to talk, right? This is how I get paid.
Me too.
Which is nice, yes. So I'm Mark Gotlieb. I am an estate planning attorney here in Boca. I have clients all over the state. I'm only barred in Florida. I am not.
Well, you're not actually barred in Florida.
Right. I'm not right. I'm not barred from practicing in Florida. I am only barred to practice in Florida. I am somewhat of a native. I grew up in Hollywood. Florida, that is, and went to undergraduate and law school up in New York. Moved back home, got my post-law degree from the U, and I practice exclusively in the area of trust and estates planning and administration.
All right. I've known Mark for a few years now, and
Don't date yourself, you know.
Please, I need to. I mean,
Right.
Look. One of the things that I really liked about the idea of having Mark be a regular participant on the podcasts is obviously his experience and wealth of knowledge, but also just his approach in terms of working with clients. And interestingly enough, it's more of a coincidence, Mark's father is an attorney. And they worked together at some point, right?
Correct. Yeah, about in 2009 to 2013.
Right.
We had our own firm together down in Miami, and then we merged. And so at that point, I moved to Boca, married, kids. He lives in Hollywood. Like many
Is he
mergers,
still practicing?
He is. He's still practicing. He's at a large firm, and he predominantly does a lot of on the international side because of our family background and his background being from Costa Rica. And so that's kind of his knowledge, and
Right.
he speaks Spanish fluently, and so we did work together, and we still collaborate together, and it's fantastic. It's a great collaboration because earlier on, like I tell a lot of people, you can't sell what you don't know, and we all sell. We're all selling ourselves. We're selling our product, which is our knowledge, and so my father taught me that you can't sell what you don't know. So I sat for 3 years next to him. I did everything. I was the stenographer. I took the notes. I typed up the post meeting notes. I did the drafting. I did the accounting. I did all that stuff, and it was a fantastic experience. He still practices now. I've been practicing for about 15 years, and it's interesting because there's things that I talk to him about that he is an expert in, so I defer to him, and there's things that I have more knowledge about at this point in my career that he calls me up, and it's an interesting full circle type of moment.
And this is one of the things I loved when Mark and I were getting to know each other professionally and as friends, is that as my listeners know here, I worked with my father for almost 30 years before he passed away, and we worked together for a longer period of time, but I started working with him predominantly doing insurance, which I hated, but you had to cut your teeth in the business. He was, as we say, the big macha, and he was the boss, and I had to, earn my chops and learn the business. And at that time, part of our practice was a significant part was life insurance and health insurance plans for corporations, and I did a lot of that. Begrudgingly, but
absolutely,
I did it, and then I left for a few years and worked on Wall Street because I wanted to get that experience, that focused experience, and I came back because I didn't love working on Wall Street. I didn't love that environment, And when I came back, now we were a little bit more on the similar level. He was always, was my hero and the person I looked up to. And I, though, was able at that point to have more of a standing in the practice and build out the investment side of it and focus on that. Sure. But it's very, very important what Mark is saying, and this rings true in the wealth management business as well, obviously, as in the legal area, that you just can't buy experience.
Absolutely. And I'll end this section with this is that is the fact that I'm constantly learning. If you're not learning, you're dying, right? Which is great for this podcast because I do estate planning. So go ahead, die.
So then they're taken care of, right?
Or not, and they still come to me because I do probate. So that's fine. But
it's a family affair.
It's a family affair. Get them on the front or the back. Anyways, I think that there is no substitute for learning from different types of people, different types of attorneys. Like you said, you kind of left your father, got some other experience, and then came back. When I left my father, I went to other firms to learn specific areas of the law that I wouldn't necessarily have gotten with him. And everything in life is a learning experience, and that's the beauty of it, right? So now that I have my own firm for 7 years in October, I have an amalgamation of all this experience that I've gotten from my father, from other attorneys that I've worked for, and I hold all of them in high regard. I never left on bad terms. They're all good people. It just was my time.
Well, it's your trajectory. It's
correct.
It's the growth that
correct.
Professionally, that you were going on.
Correct.
So,
correct.
Well, today we spoke about wills and the very, very important place that they hold in the estate planning process. Today, we're going to talk about one of the other components to estate planning, which everybody hears about, just like wills, but it is probably a larger component because there are many, many different types of I might as well say it, of trusts, and they perform different types of roles. But I want to take a few minutes with Mark and talk about generally what a trust is, because I think a lot of people throw that word out there and they don't even understand, oh, this is in trust, that is in trust, and they don't even understand what actually a trust is as an entity. And then we'll go from there and we'll talk about probably the two most common types of trust used in estate planning. But Mark, let's talk a little bit about really
sure.
Trust 101.
Trust 101.
Trust for dummies or for idiots. Okay, so what is a trust?
No problem. We're going to have the dummy give a lesson for dummies. Perfect. So every trust has three main components to it. Okay, and I always say, people talk about trusts and not to get political, but in this climate, people say, well, I don't have Donald Trump money or Donald Trump debt.
Sure, I hear that all the time.
For in terms of like trust, right? If I don't have enough money for a trust, like in terms of net worth or asset worth, or I don't need it, right? A trust on its basic level, whether it's revocable, irrevocable, and we'll get to that later on in the podcast, but they all have the same components. You have someone who is called, in Florida, it's called the grantor, the settlor, the trustor, all synonymous terms. All that means is the person creating the trust, okay? You also have the trustee. That person who's the settlor or the grantor or the trustor or the donor is giving assets to a trustee, somebody who they trust, okay, who's going to manage those assets for the third person, the beneficiary.
Or safeguard them.
Or safeguard them.
If there wasn't a management aspect really in
Correct.
place.
So think of the trustee as the puppeteer, and all the strings, you have the CPA, you have the financial advisor, hopefully at Steel Peak with John. Shameless plug.
Right. Your check is in the mail.
Thank God. But they are the puppeteer. And what do? They hire the different components and they oversee it. Right. And so any trust that you talk about has those three components. You have the donor, the grantor, you have the trustee, and you have the beneficiary. Now, one thing to note is it could be, depending on the type of trust, will depend on who those people should be.
Right.
In your typical, let's say, revocable living trust, it could be the same person. And there's no issue with that. And lots of times we do have that, and we can get into that in a little bit. But suffice to say, a trust is a legal document that says I give money and or other assets to the trustee to hold and to manage and to safeguard, to your point, for the benefit of the beneficiary.
And there are other things that could be put in a trust.
So on its base level, that's what the trust does.
Right.
And then the body of a trust, and I've seen trusts that are 10 pages. I've seen trusts that are 100 pages. I've drafted both. Every trust is different in terms of the body and the nuts and bolts of it.
Right, it's almost like you're an architect when you're
Absolutely.
working with someone like building a house. And I talk about like the architect analogy a lot with my clients, and that's what building a portfolio and everything is different for each person. In a sense, when you're working with a client, and there are obviously certain situations where you're gonna have a very vanilla, simple trust situation, and there are other ones that are gonna be more complex, where you're like an architect putting in very specific codicils or components, amendments.
Sure. So I think a good point now would be to discuss the differences between a revocable and irrevocable trust, because I would say 90% of the population doesn't necessarily know the difference. And what happens is, whenever I get a client that comes into my office, right, inevitably we sit there with an intake form. We talk about their assets. We talk about their family situation, right? I call it the cast of characters.
Right.
Every family has characters, and everyone has their own nuances and things like that we have to plan for. So it's interesting. When they come in, I go through the differences between a revocable and irrevocable, even if I know that the irrevocable won't apply to them. Why do I do that? Because this is Boca, and this is probably in every major city. They're at the club. They're having lunch with their friends. Oh, I just met with my attorney, and he said, I'm doing this irrevocable trust for my kids, or whatever it is. Right. And then I get the call from the other person saying, my attorney never told me about that I had to do an irrevocable trust. Well, that's because you guys didn't need it, so I didn't even talk about it. That's not how I do it. What I do is I go through the differences between the two in my initial consultation, and this way people are educated, so that when they are sitting at that luncheon, they're like, in their mind, even though they're not going to say it to their friends, they're going to say, I know it. I know why they're doing it. I understand why they did it. That's not my situation.
Right.
I don't need that for my particular family. But it's important to have knowledge. Knowledge is power, and that's why I do it. So, with that,
yeah, why don't we talk a little
talk
bit?
about-
Yeah, let's talk about the differences between, because there are stark differences between a revocable and an irrevocable, and really what they're used for in those.
So I like to talk about the irrevocable first, because, and by the way, total disclaimer, do not take what we talk about as the gospel. Everyone's situation is different,
yeah.
Especially on the legal side. These are general concepts, and this is trusts. Mark Gotlieb on trust. This is not anything.
This is an overview.
This is an overview.
Yeah,
so
this is 1,000-foot view of trust. It's kind of like with medication. Please consult your doctor before you take any medication.
Correct.
All right. Please consult your attorney before you start thinking about trust and what you need.
And if you
need a trust, if you need a trust and you need an attorney, please contact Mark Gotlieb. I promise you won't be sorry. And we'll give Mark's information at the end of the podcast so you can do that.
So, John, you can keep your money because I pitched you, you pitched me. It's perfect. So now let's talk about irrevocable trust, right? What is an irrevocable trust? It's a trust that, like it says, is irrevocable and unamendable on its face. Now, there's ways to amend an irrevocable trust. There's something called decanting, taking assets out and decanting it into a new trust. There's ways through a trust director or trust protector to make certain changes to an unchangeable trust. Suffice to say, there's one reason for an irrevocable trust. The point of an irrevocable trust is to get assets out of your name slash estate, semicolon. That's for different reasons. One reason, Medicaid, right? I have a daughter with special needs. I have a sister with special needs. So when you talk about, and I don't do straight elder law or Medicaid planning.
That's a whole
whole different topic. But from a special needs standpoint, when you put assets into an irrevocable trust for the benefit of a person with disabilities, that money will not be counted against them for them to be able to receive government benefits. So my daughter gets Medicaid, she gets med waiver, she gets respite hours. If, let's say, I died and she inherited $1.5 million, right? The government would say, spend that money before you spend our money.
Right.
So if it's in an irrevocable trust, it's outside
not,
of...
It's not, and I think, again, what I want to emphasize here, and this goes back to what is a trust. Trusts are entities unto themselves. Whether they are revocable or irrevocable, they are their own entities. So like we're talking about here, they have different functions and they have different constraints and restrictions. But at the end of the day, what Mark is referring to is that in moving something into an irrevocable trust, it is in there and it has really no association with him or his estate anymore.
Correct. On its basic surface, you are correct, John. And so that's one reason. Second reason is for asset protection purposes. Now, there's people that are asset protection specialists. I am not. There's domestic asset protection in certain states. There's international asset protection, having trusts in like the Marshall Islands and things like that. But suffice to say, that is a very specific type of law. And I have colleagues and friends who are much better at that than I am and much more well-versed in the latest techniques. But suffice to say, the concept is I give money, again, getting money out of my estate. I made a gift or a donation into an irrevocable trust out of my estate for asset protection purposes. I have no incident of ownership of it. Potentially, I could be a beneficiary within a class of beneficiaries in certain jurisdictions, but it's not mine. And by the way, the growth of that asset is not mine. So, and we can talk about that after.
And technically, you can't take it back.
Correct.
There's no mulligans in irrevocable trusts.
Correct. You are making a gift. You will probably have to file a gift tax return of some sort if it's over the exemption, the annual exclusion amount, which I believe is currently $18,000. The overage gets reported on a gift tax return, and it just goes against your overall exemption.
Right.
The third is for taxes, since we're talking about taxes. The third reason for an irrevocable trust is to get assets out of your name for tax purposes.
Estate taxes.
Estate tax purposes. You can never get around income tax. This is not how to circumvent income tax through trusts. This is, in fact, income tax rates in trusts, the same rates, but you get that to them at a lower amount. So it's not an income tax play, it's an estate or death tax rate. And let me just talk about that very briefly.
Yeah, I was going to say, if you could just expand on that a little bit.
Sure. So currently, the state of Florida does not have a state estate tax. Some states do. Mm-hmm. Florida piggybacks off the federal, and federal law says that unless you have close to 14 million per person, I'm just saying 14 because it's a round number. It's 13 and change, but let's just say 14 for round number's sake.
Until 26.
Until 26, and it reverts back if Congress does nothing, and they can't even tie their shoes together. But if Congress does nothing, it reverts back to close to 7 million, about 7 million indexed for inflation. But let's talk about the 14. Anything over that per person, there's an estate/death tax federally. So the tax rate is 40% on the overage. Husband and wife can shelter double that, so there's no tax till the second to die. But again, there's ways to manipulate your assets, get it out of your estate, get the growth of those assets out of your estate as well in irrevocable trusts for tax purposes. Some of the most common ones are the life insurance trust, the irrevocable life insurance trust.
What we call an ILIT in the business.
Correct.
ILIT.
There's the SLAT, the Spousal Lifetime Access Trust. There's irrevocable gifting trusts for children. Lots of times those are used to get shares that you may own of a small or closely held business get a discounted valuation, which I know is a
Right.
separate podcast that you've done. Get that discount valuation on those shares, get it out of the estate, and the growth out. So, for example, let's say I have shares of my company worth $100, because it's a closely held company and I'm the only shareholder, or maybe one or two others. It can't go on the open market for $100 a share. So we can take a 20 to 40% discount, let's say 30 on average. So $100 share, I made a gift at $70. So now I got $30 automatically removed from my estate. And then let's say those shares, I sold my business in the year, and those shares are worth now $150, right? Or $200 per share. I've gotten the discount of the 30 plus the growth out of
Out of your
my
hands.
estate.
Yep.
And so that's a really big technique that we use. So again, to kind of come full circle on irrevocable trusts, getting assets out of your estate for Medicaid purposes or government benefit purposes, taxes, and asset protection.
And they're used quite extensively. I have a lot of clients that have irrevocable trusts, and in a lot of situations, they have revocable and irrevocable trusts.
So an irrevocable trust is not going to be your sole estate planning tool.
Right.
If anything, it's an add-on, right? Even in my retainer agreement, it's a separate box. It's an add-on. Let's talk about the revocable trust. Revocable trusts are used all day, every day, mostly in jurisdictions like Florida, where probate, although it's not a bad word because I do probates and it feeds my family and I like to eat. You guys can't see me. It's cut from here up, which is great, by the way. But
Sure. I like to eat too.
yeah. Thank you, podcast junkies, for doing this. But revocable trusts are used as a will substitute lots of times. And while we like probate from a business perspective, probate it takes time, it costs money. In the state of Florida, every jurisdiction is different, meaning every county is different, every judge is different in what they require or what they want, and it's becoming more and more difficult. A lot more red tape through probate. In the northern states, like New York, I get a lot of clients that have come here from New York and New Jersey. Probate's not as big of a deal, so they just use wills. Here in Florida, you're going to see a lot more uses of trusts. And the typical trust is the revocable living trust. That revocable trust is a will substitute. It says, any assets in this trust, this is where I want it to go at my death, right? Just like a will does. It says, where do assets go at death? Again, you still have the grantor, the settlor. You still have the trustee who's going to manage those funds and oversee them. I like that word, oversee.
I like that too.
Oversee them. And the beneficiaries are going to differ. So during your lifetime, you are the beneficiary of the trust. You are the settlor. You create it. You are the trustee. You manage your funds and oversee your funds for your benefit as the beneficiary. If you become incapacitated, then there'll be a new trustee, but you're still the grantor. You're still the beneficiary. So they manage it for your benefit. If you're dead, or when you die, because we're all going to die, there's going to be a new trustee, right? Because you can't be the trustee, you're dead.
Right.
And you're no longer the beneficiary.
And the trust goes on.
The trust will
That's
continue.
an important, let's talk about that.
Sure.
The longevity. Trusts are not like one-off type of things that, you know, your parent, your dad has a trust, your mom has a trust, and it's a revocable living trust, and they pass away, and all of a sudden it's gone also.
So it's interesting, John. There's different ways to structure that part of it. So sometimes what happens is with people with lower net worths, I would say, and if the children are older, right, they may say, at my death, everything goes to my spouse if she's alive or he's alive, and if not, then to my kids. If my kids are 50 years old and we're talking about them getting $500,000 and there's no issue with the kids, then I may draft it, or the client may request, never mind my drafting, the client may want, just have it go outright to them.
Right.
Now,
just an outright distribution.
outright distribution. Then you have the clients that say, well, I have young kids. You know, I have twins that are 8, turning 9. I can't give an 8-year-old any money outright,
Right.
so we keep it in further trust for their benefit. Then it becomes, do we keep it for the duration of their life, like a
Right.
dynasty trust, and then what they have full access to it during their life, and then upon their death it goes to their kids? Or do I have it as a what we call stepped distribution, where at age 30, they can get
Which
a
we see
certain
a lot.
tranche, 35 to
Yes.
balance in 40, or half at 40, balance at 45.
Or they might even have a situation where they have the use of the money, the income or whatever for a certain period of time, and then they can get an actual
Sure,
principal
a
distribution.
right to withdraw principal.
Right.
And so there's so many different ways to skin the cat. It really depends on the client, depends on the net worth, depends on the actual cast of characters. And so that's a big ticket item. And just to give you an example, I've done trusts where the sole asset, it's going to be a receptacle for a homestead house.
Right.
That when the parents die, there's a deed we can do, a ladybird deed, where it goes from them to them during their life. They reserve the right to sell, mortgage, lease, do whatever they want to the property. And upon their death, it goes into the trust. And the trust says, where does it go? Goes to the kids. That avoids probate. It's clear for title purposes. We're good. So I've done trusts where that was the sole asset. And I've done trusts worth $50 million that are going to continue for generational wealth. And that's a very different looking trust in terms of the body, but the concept is the same. I get this question all the time, and I'm being conscious of our time constraints.
No, please. I love this topic,
this-
and I want to comment on it.
And so I'll talk about this one thing. I get this comment all the time. Does my trust protect me from asset protection? And the answer is no. The trust, the
revocable living trust.
The revocable living trust is kind of like a DBA of you. It uses your social during your lifetime, and it flows. It's a complete pass through for tax and liability purposes. So if I get into a car accident and I have a $1 million account at Steel Peak in the name of my trust,
It's attachable.
if I get into that accident, they go after the policy.
Yep.
Can they get after that? Yes. Different when the beneficiaries inherit the property, depending how they inherit it. If they inherit it in trust for their benefit, then there's an added layer of asset protection as to those assets.
Right.
It does make it harder to attack now, and by the way, a creditor can be a spouse in the event of a divorce. It could be a bad business deal. It could be someone who just got into a car accident, like I said, and that happens a lot, especially with parents that I see now with teenage kids, and they have all types of crazy things that happen to them. You got to be really careful.
Well, one of the things I've always found so interesting about trusts is the creativity aspect that can be used in them. Just in general, I mean, I've had clients where it was written into the trust that they didn't have access to the money. And sometimes, the grantor, left to their own devices, think of some wacky things. Okay, like Mark and I are Jewish. You can actually put in a trust that they don't get the money if they don't marry a Jewish person or something like that. Or you can, more practically, I've seen situations where you have someone with a lot of money, high net worth individual, and they have family to leave assets to. But say they want to leave money to a kid, but if something happens to them and they're married, they have older kids or whatever, they don't want that money going to everybody else when that person, say their
Sure.
kid someday passes away. And the interesting thing about a trust is that you can have it written. Again, that's what somebody like Mark helps somebody do, and he pulls this out of the client, is that the son might get use of the trust for their lifetime, and then say when something happens to them, it's then directed towards somebody else.
Sure.
It might go to a grandchild. It might go, instead of that way then going to their spouse.
Well, yeah, and that's one of the biggest concerns of most of my clients is I love my daughter or son-in-law, but I don't want them having access to the money.
Right.
And so we plan for that accordingly.
Well, and that's why I wanted to
thing-
bring it up, because it's a
Sure.
huge estate planning component.
Well, and coupled with that are the couples in Palm Beach County, for example, that are second marriages with kids
Third
from
marriages.
second, third. I have a few clients that are on their fourth or fifth marriage, against my advice, by the way. But they have to plan for a spouse, and they could be married to their new spouse for 20, 30 years, but they have kids from the prior spouse, and how does that work? One thing I did want to add, just briefly, whenever you do a trust, you still do a will, because I get that question all the time.
That's a good point.
And that will is at that point a pour over will. It says literally, if I have any asset in the world that I had forgotten about, I did not either put in the name of the trust, meaning title in the name of the trust for funding, or designate into the trust at death for funding purposes. So now there's an asset that's out there that's potentially in Mark Gotlieb's name that was not jointly owned with rights of survivorship, jointly owned as husband and wife, designated with a beneficiary, or in the trust. So it's solely in my name. There's a probate on that asset. And what happens is the will basically says at that time, whatever assets that have to go through probate, pour into my trust at my death, and the trust is the beneficiary of my estate. The trust then dictates where things go.
Right.
So that's
and that way you have a
come full circle.
trustee and not the courts determining where
Correct.
where things go.
Correct.
And the trustee, usually somebody close to that person, has an idea of whether, it could be estate jewelry, it could be something like that.
Anything from personal property, shares of companies, and money, stock accounts, things like that.
Well, we're running up against our time here. Again, thank you, Mark, for coming back and
Always a pleasure.
imparting your wisdom on us. This will be something we continue to do on the podcast. Mark, why don't you just, if somebody wants to get in touch with you, just give a phone number and an email maybe where they could reach out.
Sure. So my website is gotlieblaw.com. Gotlieb is spelled with one T. I couldn't afford two. Now that back in the day they couldn't afford two. Now that I can, I don't want it. That's
simplicity.
By the way, that's my dad's joke. I will give him credit. Thank you, Dad. My phone number is 561-250-7526. My email is mark, M-A-R-K, at gotlieblaw.com. Again, G-O-T-L-I-E-B. Gotlieb with one T and Mark with a K.
And we will definitely have Mark come back. If anybody watching the podcast has any specific topics in the area of trust and estates that they would like to hear us talk about, please send me an email. Again, my name is John Perry with Steel Peak Wealth. As you can see on the screen there, my email is john.perry@spwm.com. And you can hear our previous episodes on Spotify, Apple, or YouTube. And again, Mark, love having you.
Such a pleasure, as always. As a friend and as a colleague, I just love coming on your podcast, and you're a wealth of knowledge.
I love having you here. We will talk to you soon. Have a great day.